Thank you all for joining today. We will discuss the new contours of the crime of terrorism. We will focus on the complex balance between justice and accountability in the context of contemporary transnational terrorism. In a time marked by evolving norms, challenge to the rules of law, and strong concern over national security, advocates across jurisdictions face a critical question: how can we uphold defendants' rights while ensuring effective measures against terrorism and protect the public interests? How do we navigate this tension while maintaining the integrity of the legal system? So before we get straight to the point, Somaya, now and Bonita will introduce themselves. Somaya, please, could you introduce yourself, please?
Thank you, Julia, for this. My name is Sumaya Slim. I'm an Egyptian human rights lawyer, and I'm also a researcher specialized in justice, migration, and displacement through gender and environment conditions. I served as a deputy director secretariat in the Congress of National States, CNS. It's a global civil society as a platform for the rights of indigenous people, stateless communities, and other marginalized groups. My work focus on how counterterrorism and security law affect on civil space, about the relationship between the climate change and displacement. I work as a woman as a human rights defender in Middle East, and now living exile. Thank you.
Thank you. Thank you. Now, can you introduce yourself, please?
Thanks. My name is Narcissa. I'm working with Women's League of Burma as political initiative and advocacy delegates, as well as also I'm a career women's organization advocacy director, and I work for the human rights, especially women's rights, as an activist and a human rights defender for 70 years. Thank you so much for this opportunity.
Thank you, Na. Bonita, could you introduce yourself, please?
Good day, everyone. My name is Bonita Ayuko. I'm a lawyer specializing in access to justice and security sector reform. I'm also a peace-building practitioner, and I undertake mediation. I'm engaged in mediation processes. I've been working on legal empowerment, conflict sensitivity, and democratic governance. And I have led researches on access to justice and human rights. And I've also been engaged in contextual analysis, especially to advise on conflict issues for purposes of interventions by security and peace actors. Thank you.
Thank you. We will start with my first question. What practical safeguards can help keep counterterrorism frameworks aligned with the rule of law and human rights obligations? So Maya, perhaps you can start provide us with your Egyptian point of view.
Okay, from the Egyptian context and experience, the real dangers began with elastic definition. The first ground is definition precision. Terrorism must mean violence against civilians, not peaceful dissent. The second point is that we must apply ordinary judicial safeguard to terrorism case, like public hearing, credibility evidence standard, and presumption of innocence. In our context also, there must be international or regional oversight through periodic like UN or African review. This could help expose misusing and rebuild public trust. And finally, I think law must be gender sensitive for women face digital harassment or surveillance in ways rarely acknowledged by security frameworks.
Thank you. We understand now that in fragile contexts like Myanmar, the first safeguard is clarity. Are you agree with this statement?
Yes.
Can you explain us what type of safeguards can help, according to you, to keep counterterrorism frameworks aligned with the rule of law and human rights?
As Burma safeguards, especially in the counter-territory framework, we in Burma, safeguard content framework frequently contains and involves several measures and two alone aligned and especially with the human rights with a clear definition, strengthening judicial oversight for the accountability, and that training or law enforcement or capacity building, all those things in also human rights in human rights as well, and then to engage with the community to build the trust, establish the transparency mechanism, collaborate internationally, as well as also to share best practice like involving civil society in policy development, and that also support survivor or victim of the terrorism of the dignity. Yes.
Thank you, Na. Somaya, you will make a short presentation. You can perhaps go through your presentation, and we'll proceed with the question after that.
Okay, thank you. In fact, I prefer to start with this presentation because it will make people understand the Egyptian context more. As we are going to discuss, they will understand what I'm speaking with. So thank you for this, and good
You're
afternoon, everyone. When we talk about the new contour of tourism, I like to highlight a simple truth. The most dangerous counter is not new at all. It's the absence of definition itself. Across the world and in the Egyptian context, the failure to define tourism create a legal space so elastic it can stretch to fit anyone the state wants to silence. That's why I call it the elastic enemy. Next, please. Egypt's main counter-tourism law is 94 of 2015. It turns ambiguity into a system of rule. Phrases like disturbing public order or harming social peace allow prosecutors to turn criticism into crime. This ambiguity is not a flaw, it's a strategy. So the law that must meant to fight violence is now fighting voices. Next, please. Today, the crime of terrorism has moved from battlefield to screens. Tweets, posts, and even news articles can be treated as a threat to national security. Courts have accepted screenshots as an evidence without verifying them, and digital monitoring systems feed directly into prosecution files. In Egypt, expressing an opinion online can carry the same legal weight as committing an act of violence. Next, please. This makes us ask who the tourist is. The target is no longer the person who plants a bomb. It's the lawyer who defends detainees, the journalist who is exposing corruption, or the activist who dares to write a hashtag. In 2025 alone, more than 90 human rights lawyers and defenders were referred to tourism court in Egypt, not for violence, but for doing their jobs. This criminalization of professional duty violates the UN Basic Principle on the rule of lawyers, which guaranteed independence and protection from interference. When defending justice itself becomes a crime, the law stops being a shield. It's become a weapon. Next, please. Here, what's happened in practice. When journalists, lawyers, and activists are arrested under terrorism case, they are accused of joining a terrorist group and spreading false news. They are held for up to 2 years in pre-trial detention. When the limit is close to the end, instead of being released, their names are recycled into a new case with the same charge, the same evidence, and no trial. This is what I call the circular logic of persecution. You are never acquitted, never convicted, just endlessly detained. This circular process transforms legality itself into a trap. When ordinarily online expression becomes a terrorism, the line between justice and control completely disappears. Next, please. The third counter lies in the courtroom itself. Terrorism cases in Egypt are not handled by ordinary court, but by special terrorism circuits. The circuits operate under different rules: closed session, limit defense participation, and heavy reliance on secret police investigation. It's a system designed not to determine guilt, but to guarantee convention, a parallel universal where due process is suspended in the name of security. Next, please. Behind it all lies fear, what I call political anxiety framework. The state constructs a constant sense of fear, and the society is desperate for stability, accepting repression as the price of safety. It's an old colonial logic, dressed in modern language, managing population through fear, not love. In Egypt, counterterrorism has become less a response to violence and more as a strategy of governance, one that uses law to silence anxiety, not to resolve it. Next, please. This moves us to what happened or what is the result of all of this. First, the collapse of civic space. When lawyers, journalists, and NGOs are labeled tourists, civic space shrinks to silence. By 2025, nearly 90% of dependent NGOs in Egypt had been shut down or frozen. Dozens of media outlets were broke down or forced offline, and even legal aid organizations were persecuted. People censor themselves, organization withdraws, public life become quiet, not because peace prevails, but because fear does. When everyone can be a tourist, no one feels safe. Next, please. The next result is gender. Counter-terrorism frameworks are never natural. In Egypt, women are either invisible in the narrative or instrumentalized, portrayed as a victim or as a symbol of morality. They are rarely recognized as a political actor in their own rights. Next, please. In reality, this gender repression plays out in two spaces, digital and physical. Online, women activists, lawyers, and even relatives of detainees are accused of misusing social media or promoting terrorist ideas simply for posting about injustice. They face defamation campaigns laced with sexual threats to silence their voices. Offline, sexual violence in detention and public space is used deliberately to punish women for speaking and to mark public space as unsafe. These are not isolated incidents. They are messages meant to keep women quiet. And yet, women continue to resist through cyberfeminism, storytelling, and community care. Their defense reminds us that silence too can be broken. Next, please. The third consequences across border. The elastic enemy travel with citizens. Once someone is charged under Egyptian anti-terrorism law, evidence without conviction, the legal consequences follow them abroad. Exile and former detainees often find themselves legally erased, unable to renew vital documents like passport, IDs, either for themselves or their relatives. Without those documents, access to education, healthcare, and even legal residence become impossible. Crucially, children born abroad risk potential statelessness. This repression extends through visa rejection, frozen accounts, and watch lists. Some are even detained or deported despite no violent charges. Exile becomes a family sentence, especially for women who bear the double burden of displacement, isolation, and sustaining families without legal recognition, under constant fear of return. Next, please. This brings us to what I call the global disconnect. On the international stage, you will notice they praised Egypt for stability and counterterrorism cooperation. What this narrative ignores is how counterterrorism itself become a form of repression under the name of security. And when geopolitics speaks louder than justice, law becomes diplomacy by other means. That's the quiet hypocrisy at the heart of our international order. Next, please. So, where do we go from here? We start by reclaiming the definition itself. We must draw a bright and unmistakable line between two things: real act of violence against civilian, which must always be condemned, peaceful political dissent and expression, which must always be protected. The misuse of term terrorism has turned it from a tool of protection into a weapon of persecutions. Next, please. What we need now is precision and courage, both legal and moral. That's mean, in my opinion, a new international convention with a narrow rights-based definition of terrorism, a UN mandate review mechanism to monitor how states apply these laws, and safe grounds that protect civic space and women's rights in all counter-terrorism cooperation. Because ambiguity empowers repression, while accountability restores law. Next, please. So, the question I end with is simple but urgent. Does counterterrorism serve justice or politics? In Egypt, people are punished not for what they do, but for what they represent. Their words, affiliation, and beliefs become criminal evidence. And when the line blurs, the law no longer distinguishes between a terrorist and dissenter. This is not just an Egyptian issue, it's a global warning. Whenever definitions are vague, repression follows. Next, please. The Egyptian experience shows what's happened when terrorism defined by political rather than principle. Justice itself becomes the first casualty. Until the world agree on what terrorism truly means, the term will keep serving fear more than safety. That's, I believe, is the conversation we must keep alive if we ever hope for law to serve justice again. Thank you.
Thank you, Somaya, for this very strong presentation and your message. And we understand that terrorism is a word used sometimes to as a tool to circumvent the normal course of justice, and that we have to deep in the veritable reason of act, to be sure that it's not a political act but a real violence. So thank you. Now, would you like to present your presentation regarding terrorism and the application in your practices in your country?
Yes.
Yes, thank you.
Thank you so much again. Also, was that so my end presentation also it's really strong regarding on the especially the terrorism terminology definition, as well as also how our content has applied, even the terminology and the practical, it's totally different. Sometimes also get impact for the people who are facing or affect the human right or any other violations. So for me, especially the strengthening the evidentiary standard in the terrorism trial. So here, some part that I would like to mention here. So international norms is really important. Mostly we always advocate to policymaker whatever they think about or whatever they implement or do it to include the international norms. So here the what I say international norms, so use framework such as the UN established the fair trial standard, created a common evidentiary understanding. Another part is capacity building and a training program. So conduct joint training or fair trial rights and evidence handling for law enforcement, judiciary, and legal practitioner. Because in Burma context, even the law or the standard as international standard or norms has agreed principally, but the people who are implement, especially like law enforcement or judicial or legal practitioner, all those are not aware or don't understand much of the law or any of those things. So when they practice or when they do implementation, sometimes it's not fair or get it justice or accountability for the survivor and victor. So in Burma, we have see law enforcement because of those people, who are taking part of the law enforcement or rule of law. So they are not aware and they don't even understand of this. They just do as a comment. They just do whatever the comment from the top leader. So they just do that. They don't even understand. And then another thing is the share resources, provide technical assistance from the international judicial bodies to improve the evidence gathering. It's really important if we can organize to share resources, for example, a lawyer to lawyer, or even like a law enforcement to understand more the term or the thing that they need to be considered when they do implementation or take action. Another thing is created safe channels for collaboration. Maybe dialogue forums, creative platform, or local, national, as well as also international stakeholder to discuss the challenge and the best practice. These are very lack of action or lack of cooperation between international and national, as well as also local and international. They're very very weak of this channel to give to get a safe as well as also collaboration. So this is what we see it in Burma. I don't know, even in the other country also they might have this gap as well. And then monitoring mechanism is really important. We whatever we planned, whatever we have, we have a law or enforcement, any actor or any a paper or a policy or law, but without monitoring and evaluation mechanism, so we will not see it, what improved and what need to be improved. So, and that all we can even get to improved content as well. So the monitoring mechanisms are also really important to CAMAS, so can establish with the independent body to review, try, and ensure the standard that so they may have a regular to review or to monitor, and so they can give the weak point, the strong point there, that the actor can how to say improve themselves on times. And that the public reported, it's also important. The issue report on tri-student to promote especially accountability and public trust. It's really important for the any countries that they are accountability on something, so they must be transparency as well. Also, they must build the trust between the community. So but it must be without revealing sensitivity information. So we know some of the information that we can even public, but at least what we need to public to the people to aware of this, and how the taking action or accountability and responsibility on that. And so in the prioritization accountability in Burma, it's really neat, and we always because in Burma, as you see in the photo, I don't even mention about the counter problem much, because you may already heard that the military coup happened, and human rights violation includes crimes happened, crimes against humanity, war crimes, genocide happened in Burma, and we face these ongoing impunity over 70 years, over 70 years. So what we really need to have to prevent to have the human rights protection, especially preventing the impunity, to end the impunity. Otherwise, we don't even take accountability as international law or international crime. So it means that you allow the perpetrator to keep continue and to violence, to commit crimes without accountability. So as we people from Burma, we seems that the perpetrator, especially the military junta, they are committing international crimes, war crimes, crimes against humanity, and genocide. So international must be take as responsibility and take effective action. So this is also the topic also mentioning the accountability as well. So we want now, and we mention here preventing impunity, because we must hold the perpetrator accountability for human rights abuse, deter the further violation, and support a culture of the respect of the human rights. Another thing is survivor victor justice is also really important, not only finish at the end of the accountability, but also how we acknowledge and accountability provides justice for the survivor and victor with their family as well, and that contributed to healing and reconciliation. And that democratic principle. So most of the government, however, they come out with a system, but they used to use the practice working as a democratic or practice as a democratic, or they must have a word in the constitution mentioning or law mentioning about democratic principle. But in reality, they don't even practice as well. So this is really important to support democracy, especially accountability is a victor for the functioning democracy. So whatever we functioning or whatever we create a platform, or it must be functioning with the democracy. Yeah. So another part is international relationship. So international relationship also credibility with the global community. So demonstrating accountability can improve, especially Burma, Myanmar standard in the international community. and potentially leading to increased diplomatic and economic support. Another point is long-term stability. Social cohesion, it's one of important in Burma now. So it also addresses past grievance through accountability, can reduce tensions and also promote a long-term social stability. So what especially we advocated for women's voice, and also we advocated for the accountability for the crimes against them. The strengthening voice encourage women to take a leadership role in the security discussion as well as also decision-making process, ensure their perspective are included. Training program offer training for women to build skill in advocacy, negotiation, and public speaking, empower them to accumulate their demand effectively. And that also highlighted agency, shift the focus from the women's solely as a victor to recognize their agency and contribution to peace building, security, and conflict resolution. Rebuilding public trust in justice system is also really important to consider. So acknowledging past abuses or violations, and that we might need to apologize some that we have committed or mistake. So these things are also really important to rebuild the trust between stakeholder or policymaker or government or a community. So authority should acknowledge past injustice, and that offer formal apologize to a victim or survivor and the community affected by the abuse or violation. And a truth commissions. Truth commission also one of we show our accountability and try for justice and accountability. Even the violation have been passed many decades, so the true commission must be taking place to address this, that we can rebuild our trust with the community. So it established the mechanism to investigate and document abuse, provided a platform for the survivor victim to share their experience. And that also reforming institution also it's really important. If even we have very institutionalized or very dominant institution, it will not work, and also the trust, community trust also will not increase as well. So we must have a review on that, and what we need to reform institution, we must reform it. So independent oversight, create independent oversight, especially create independent body to oversee policy and judicial conduct, ensure the accountability for wrongdoing, and the legal reforms. So we must also review and all those things, and if needed, update law to align with the human rights standard, focus on transparency, finance, and also the protection of the civil liberty as well. And then the last is the last 2 point is the community engagement. So dialogue initiative or participatory governance. So if we have to facilitate open discussion between law enforcement and justice official and the community in Burma, when we see the law enforcement wearing uniform, we already afraid, because they are mostly forced to do things. They force and they torture and they are also doing so many human violations. So people are very, very afraid of them when they even see their uniform, include the military. So this will not have trucks and will not be a trucks. So these are also one of the thing that we must build up in the country, and that also to open or involve community representative in the developing policy or practice to ensure the need and concern are prioritized. Another point is the education awareness raising is also really important for our people between the government and also the community. So public outreach are also really effective. We can even use many ways within the current situation. We use different technology or social media. So many ways that we can reach out things. So conduct campaign, education public about their rights and the rules of the justice institution. For tourists, get greater understanding and engagement. A training for officials are also really must be long term and regular section or programs for that to provide training of for law enforcement and a judicial official focuses on human rights and a community relation and respectful policy. Thank you so much.
Thank you, Na, for explaining how it is important the accountability as safeguard of misuse of the terrorism word and the necessity to rebuild public trust in justice system through a renewal of institution, the relationship with other and the education of people. So thank you for that. Bonita, we will listen to you now.
Okay, thank you so much. And thank you to the previous speakers. Just to mention that their context, I also resonate with the discussions that they had, despite the different contexts. Those are some of the issues that we are facing. So I'm going to give you the context in Kenya. I'm going to look at it from the point I'm going to use 3 case studies just to allow the viewers to also see what it is that we're experiencing and how we have been able to deal with it, touching on human rights and also prosecution and rights of defendants and even those who have experienced arrests or been detained for the reason of terrorism. So I'll be presenting on the topic of emerging threats of terrorism and the evolution of international law, specifically looking at Eastern Africa, that is the region. It provides both acute challenges and valuable lessons that are shaping the global narratives on legal responses to terrorism and the balance between security and human rights and the necessity of cross-border legal cooperation. Eastern Africa encompasses countries such as Kenya, Somalia, and Ethiopia, amongst others, and has experienced a persistent, sophisticated threat from terrorist organizations, including Al-Shabaab, ISIS affiliates. We have porous national borders, extensive areas outside state control, and the rapid spread of digital technologies have together created what we describe as a perfect storm for terrorist operations. For legal practitioners and policymakers, these realities have demanded both rapid adaptations and deeper cooperation within and beyond our region. In response to this evolving threat landscape, the states in Eastern Africa have adopted progressively more robust anti-terror laws. For example, in Kenya, we have the Prevention of Terrorism Act and its subsequent amendments that have become central to national counterterrorism strategy. However, despite these reforms, legal frameworks have often struggled to keep pace with the innovations and especially concerning digital technology, cross-border management, and ensuring respect of due process and human rights. Limitations in regional legal cooperation and differences in national legislation also continue to hinder unified action. Across the major terrorism cases in Kenya, we have the Westgate Mall that happened, Westgate attack that happened in 2013, the Garissa University attack that happened in 2015, and the Dusit 2 hotel attack in 2019. So these three, they give distinct legal evidentiary lessons that are shaping both national and international approaches to counterterrorism law. The Westgate case highlighted challenges in collecting actionable evidence amidst all the chaos, delays in prosecution, limitations of relying on witnesses' testimonies and physical evidence alone. While convictions were secured for those who facilitated and planned the attack, the alleged masterminds either died or escaped, and this led, of course, to accountability gaps. The Garissa University case exposed the need for robust conspiracy and communication evidence. The prosecution used phone records and digital trails to tie suspects to Al-Shabaab, and this secured convictions for conspiracy and material support. This was despite limited physical evidence at the crime scene. This case demonstrated the growing reliance on telecommunications and digital networks for securing convictions in terrorism cases. The Dusit 2 hotel attack marked a breakthrough in the use of digital finance evidence. So prosecutors in this case traced mobile money transfers linked to the attack, securing convictions in 2025 for individuals who coordinated finances and communications, and investigators used intercepts and forensic analysis, affirming the importance of digital capacity in modern legal responses to terrorism. So we see technology now at the heart of both the terrorist threat and legal responses in Eastern Africa. So mobile money services, such as in Kenya, we have M-Pesa, and it is used broadly in Africa, are frequently used by terrorist groups for fundraising and logistics, while encrypted messaging apps enable covert communication and recruitment. Prosecutors have achieved convictions based on digital financial transactions, marking significant progress for us in our court processes. Nonetheless, the pace of legal and technical adaptation remains a challenge, especially as the threat landscape grows more sophisticated each passing year. So efforts to counter terrorism have sometimes crossed legal and ethical boundaries. For example, during operations, we had operations in a forest called Boni, where it was cordoned off because it was believed to be a host to terrorist groups that were hiding in the forest. And many people were arrested from the forest, including the locals. And there were many documented cases of arbitrary detentions, torture, and denial of legal rights. Significantly, the judiciary played a central role in enforcing constitutional protections, awarding damages for due process violations, and reaffirming the rule of law, even under extreme security pressure. This experience underscores the region's ongoing struggle and commitment to ensure that security response do not undermine rights and justice, taking into consideration that this particular area is actually at the border of Somalia and Kenya. There's a wide recognition that terrorism cannot be contained by national borders, obviously, and regional institutions for us, such as IAPCO and IGAD, work to coordinate legal strategies, intelligence sharing, and operational planning. These institutions have pioneered important innovations, but they still face challenges, particularly when it comes to full ratification, harmonizing legal standards, and overcoming resource constraints. Sustained regional unity and investment then remain critical for any future progress. Shifting, an important feature of the terror threat in this region is the active recruitment of women and youth. So these recruits may play supporting, operational, or even leadership roles within the terrorist organization. This reality then serves to complicate the legal response. For example, when addressing the blurred line between victimization and agency. Increasingly, the states and civil society are engaging in new strategies for prosecution, rehabilitation, and reintegration, which must be sensitive to gender and the social context if they are to truly disrupt the cycles of radicalization. The experience of Eastern Africa then yields some lessons for improving legal response to terrorism. First, the need for constant modernization and harmonization of anti-terrorism laws. This, of course, cannot be overstated, and the previous colleagues also talked about the definitional challenges, and also taking into consideration that technology and tactics also change, and they're changing rapidly. There must be strong investment in forensic evidence preservation and digital investigative capacity. The third is the defense of human rights and due process safeguards. They must be viewed not as obstacles to security, but as foundations for lasting legal legitimacy. And fourth, regional cooperation, deepened mutual trust, knowledge sharing are vital for resilience against transnational threats. Of course, this applies both at the regional level, national level, and also at the community level, because there must be trust building at that level before it also picks up and can be taken up by other structures and institutions. So in closing, Africa's journey in confronting, Eastern African journey in confronting terrorism just offers rich experience, of course, from the courtroom to the front lines of policy and security. The lessons reveal both enduring trials and inspiring progress. As legal professions, there's a lot that we can learn from this, and the determination to try and build up on legal systems that are adaptable and just and resilient. So yeah, that is the end of my presentation. Thank you for your attention.
Thank you, Bonita, for this. Yes, your last words regarding the balance between security and justice is it's the point of our discussion today. We have seen from your presentation that certain anti-terrorism law can be misused and endanger justice and fundamental rights, as well as limited the right of certain group of people, and particularly women. We have also seen that this law can be useful in protecting against a phenomenon that is growing worldwide, the terrorism. How do you think we can find a way to ensure people safety while allowing certain exceptional measures necessary in the fight against terrorism?
Okay, I can begin. Oh, sorry.
Yeah.
Yeah. Okay, thank you. So I believe that it just goes back to how I ended, that there needs to be involvement of communities, especially when reviewing formation and reviewing of those terrorism laws. How do we engage security and communities? Do we bring them together to dialogue, to talk about the needs, the issues that are arising in those particular areas, so that whatever policies are reached, whatever laws are passed, actually respond to the issues that have been highlighted, rather than coming up with legislations and then rolling them out, and people then, of course, are going to be against them. Then we need to be very careful about counterterrorism powers that can be used to suppress political or civil engagement. And Somaya mentioned it in her presentation, and it's also something that has been a challenge. Probably it has to do with the definition of terrorism again. So at what point do we leave a broad-based definition at the global level, and then leave regions and countries then to define what terrorism is, depending on their circumstances, so that then this is what is going to be followed up even within the court system. So there are those dichotomies that we need to also take into consideration, have a broad definition at the global level, so that there's no ambiguity. That ambiguity is what is being taken advantage of and being used, especially against dissenting voices within our nations. Thank you.
Thank you. Somaya,
Can I step in?
yeah.
Okay, thank you, Puniti, for what you said and for referring to my presentation. And I would like to add on what you said about transparency, because trust starts from this. People need to know what is the law means and what is the applies equality, and it applies equality on everyone. And there must be a safe ground for the civic space and civic society to monitor trials and for the independent legal aids that that will send a strong signal that justice, not fear, is driving this process. Also, in my context, as I said, there is a case recycling. So it has to be an end for this, because as the person is in pre-trial detention, it mustn't be simply renewed itself by another number to gain another space for pre-trial. So I think that even the international reporting and oversight from UN, African organizations, stuff like this, can help in making this monitoring for the states and how they apply this kind of law. And instead of saying that there is a law or no, it's just need to be following the procedure, how they apply this law, how they protect innocent people, and they protect the right for expression, and how they express about themselves, or maybe criticism the policy without fearing from being charged with terrorism. Thank you.
Thank
I
you.
just want to add a little bit. Actually, Somaya and Bonita already mentioned very concrete. So basically, when we see the country, they develop the law or policy or discuss the terminology of the even, for example, terrorism or anything. So mostly they do top down, no? they do at the top, and actually all those things are applied in the ground. That the ground people doesn't know and it doesn't aware of this. So it should consider how the policy or law development process must be bottom up. Then the community can evolve, and there the voice of the concern, the voice and the concern of the community must be come up at the first step. No, that the law expert or lawyer or other international expert can base on that and develop the law. So I think we must think about the approach, no, when we develop the law or the policy. So this is really important to consider all these things as well. And then the truth and acknowledgement also is really important. So when we say it when we develop the law, we must also accept the truth, the happening, or what happening, what the true happening. So then also we must also acknowledge, oh, this is really happens. So we how we must how we going to develop and guarantee not to be happen, how we must protect in the laws. So if we accept it or of those truth happening or acknowledge that, so the law that we going to develop or redefine or whatever we review or revise, so will be more how to say concrete or strong, and that also will be in line with the ground. So we see the ground happening, and we want to prevent prevent and protect in the law. So this is also important. Thanks.
Thank you. Thank you for this rich exchange, which demonstrates that the issue is broad, opens on complex topics, and is highly relevant. And thank you also for your optimism and for reminding us that the justice and the fundamental of law must prevail in all circumstances, even in case of terrorism. And we did not find the good definition tonight of the terrorism, but we open many topics very interesting. So thank you, Na, thank you, Bonita, and thank you, Somaya, for the presentation and your words.
Thank you so
Thank
much.
you so much.